Password.
May
Password 230.
make one submission.
I told him.
Yes, scholars.
May make one submission.
Password at
List number 2, serial number 8. Interim audit has to be continued.
Huh?
Interim audit has to be continued. List number 2, serial number 8.
Why you are making mention now?
It was not reached. Therefore,
Read.
please, madam.
Yes. Yes.
Leave it.
Yes. Yes.
There was a compromise for complaints of,
Yes.
on a complaints of a compromise, we have approached the ROC. The procedure is already started. Ma'am. Another 2 months, probably it will be, the name will be struck out from the company. That is a compromise.
No, that is the execution.
Yes.
That is the execution. So why should they stay?
Well, it's prior to that, my lords, there were 2 crores overburdened. So we had applied for some financial support from KCFC. So all that amount is being paid now.
No,
Until
the issue is, there is a compromise decree.
yes, my lords.
For execution of it, a compromise petition is filed.
Yes,
Why
ma'am.
should this court stay it?
The reason is, my lord, the person who had compromised is no more now. The legal representatives have now, they have taken efforts to close the entire thing procedure. It is under the process, my lords. Another 2 months time is granted. This becomes infructuous, my lords. For that reason, 2 months time may be granted. By the time by 2 months, it will be strike it off.
I'm only on the merits of it. You have to convince me on the merits. Why the order? What is wrong with the order passed by the trial court?
My lords, the facts are like this, my lords. We entered into an agreement with them. Subsequently, they did not give us any opportunities. Later on, from 2013, there was a memorandum of understanding between the company and my client, the respondent company and my client. So nothing happened. So subsequently, they struck out. In the year 2018, there was a compromise between the parties. In that compromise, the present client's father had executed a compromise that he will remove the name from their company. We are not using their company. There is no factory also. Everything is closed.
Okay, complete it. Remove that name.
It is under the process, ma'am. It is in the
From 2019 to 2026.
my lords, we had raised some loan. We have to, unless and until we make the payment of the loan, the company will not take us forward to remove their name. That was the reason, my lords. I can produce all the documents now. 2 crores and change.
We have to look at the legality of the order, not
True, my
your
lords.
inconvenience.
My lords, my indulgence is, my lords, only 2 months time may be granted. By the time this petition itself becomes infructuous, because we would have complied the order, we will withdraw it, my lords.
File an affidavit before the court tomorrow. On Monday, I'll take up this matter.
Very well,
with
my
an
lords.
affidavit.
Very well, my lords.
List this matter on Tuesday. By the time it is submitted with the land counsel, the petitioner, that within 2 months they'll be complying with the They will comply with the conditions imposed in the compromise decree. In that regard, an affidavit shall be filed before this court. List this matter on Tuesday.
Grateful.
Serial number list continuation. Serial number 56. Vachan, HU for petitioner.
Here on behalf of the advocate for the petitioner.
7S P. Kumar.
Defendant's petition about an order passed on an IA directing the police to intervene and evict me from the property. I take my lot to the impugned order, page 19. The long history to this matter.
First, we will see this order.
Impugned order, I will try to point out. At page 19, here the defendant's matter.
Yes.
If I may be permitted to read portions of the order. Order on IA number 8. IA number 8 filed by the plaintiff under section 151 of CPC, praying for directions to the SHO of Whitefield Police Station to assist the plaintiff in implementing the injunction order passed by this court on IA number 1 and 2, which were confirmed by the Honorable Supreme Court. Para 3. Application resisted by the defendants by filing written objections contending that application is not
No,
maintainable
where
either
are you reading?
on para 3, page 21.
Hmm. Yes.
Application resisted by defendants by filing written objections contending that application is not maintainable either on law or on facts. Similar application was filed and same application was allowed, and directions were given to the SHO of Whitefield Police Station to implement the injunction order with respect to plaintiff scheduled property. On 1/2/2025, police submitted detailed report. Honorable Supreme Court in the decision reported in so and so held that the principles of res judicata are not only applicable to subsequent proceedings but are also applicable to subsequent stages in the same proceedings. Same was reiterated by the Honorable Bombay High Court in the decision reported in so and so. Hence, instant application is not maintainable. Plaintiffs are not in possession of the suit Schedule B property. Honorable High Court of Karnataka in writ petition so and so and writ petition so and so, that was between the parties only, decided the question. Honorable High Court of Karnataka directed the police authorities to maintain law and order by following directions of civil court and not granted any relief for eviction. No grounds are made out to allow instant application and no change in circumstances were pleaded. Plaintiff and his family members tried to enter on the vacant space. Defendants cannot be vacated without due process. Defendants are in peaceful possession of a valid title. Hence, pray to dismiss the application. These were all my defenses. Now, my lord, will see what the trial court says. At page 23, at the bottom,
Yes.
orders of this court shall be implemented. Orders cannot be in papers. Points urged by learned counsel for defendants in his arguments having no force and hold no water. It is a duty of the court to implement its order. Photographs clearly show the illegal acts of the defendants. Hence, these acts shall not be condoned, should be there. Accordingly, this point answered in the affirmative. The order that is impugned now, IN number 8 filed by the plaintiff under 151 CPC is allowed. Issue directions to the SHO of Whitefield Police Station to implement the orders of this court passed on IN numbers 1 and 2 on 2/6/2025. Issue further directions to the SHO to implement the order and to file compliance report. SHO of the said station further directed to remove any obstruction placed by the defendants in plaintiff B scheduled property. Office is directed to issue further directions to the SHO. If SHO fails to implement the order, strict and stringent actions will be recommended. This is where brings me to this honorable court. The history behind this, my lord, we'll see at page 318 in the second volume. My lord, 2 volumes are given. 318. This is a decision of this honorable court in RFA 1664 of 2012.
Yes. Yes.
318. This RFA is, if my lord will see here, we are the defendants are the appellants here. The defendant number 2, his name plaintiff's father. Basically, what I'm briefly I point out this, my lord. I'll take my lord through the records. But my case before your lordship is this. We had purchased this property way back in the 80s from one Sharda Baliga, plaintiff's grandmother. His father and his uncle initiated litigation against me. Suit for partition was filed, contending that the mother was not the sole owner of the property, joint family property, etc. Trial court held against me. I came before this court in this RFA. In this RFA, the court, this honorable court, gave a categorical finding. It was a sole and absolute property of the grandmother, plaintiff's grandmother. She has herself filed a written statement saying that yes, I have sold it to these defendants. So her written statement was also taken note of, and the honorable court said there can be no interference. His title is perfect. I succeeded in one round against one generation. This comes in April 2024. December 2024, the grandson goes and files another suit. In that suit, he says that my grandmother had left a will. In the year 1994, there has been no whisper of the will for the last 20-30 years. He goes and files a suit saying my grandmother had left a will bequeathing the property to me, therefore declare me as the owner. No mention of the suit for partition, no mention of
I
the
think you
RFA.
don't have to go into all that in the light of the injunction suit attaining finality by the Honorable Apex Court.
Pardon, my lord?
Injunction suit,
No, there is no injunction suit.
then what is this execution?
Well, there is no execution also. I tell you, my lord, what has happened. So this is where
No, what is the matter before the SLP?
I have filed an SLP before the honorable court. I mean, they had filed an SLP before the honorable Supreme Court challenging the RFA of this court, this order. That got dismissed. When the injunction came to be granted in this grandson suit, an injunction came to be granted. I challenged it before this honorable court, I challenged before the honorable Supreme Court. Both courts have held it is a discretionary order. You do your, the trial will be expedited, you deal with it in the trial court. So that is where that matter.
Against the interlocutory order.
It is an interlocutory order. It is no decree has been passed. We are at a very bare interlocutory stage. On IA number 1, 19th December 2024, order was passed against me saying that I should not interfere. Police come. Police say interfere no. There is a report which I point out. Defendant is in possession of a portion of the property. Plaintiff is in possession of a portion of the property. That report was filed. They challenged that, the police actions, before this honorable court in 2 writ petitions. This honorable court has categorically recorded police will not intervene in civil court proceedings. Civil matters and all should be decided by the trial court only. Their counsel statement is recorded. My statement, I was only present. My statement is also recorded. That order is also produced here. I produced this before the trial court. They had filed a second application saying that police must interfere. There the trial court says, High Court is seized of the matter. High Court is already looking into it. Same relief is sought before the
Where is that earlier order of the High Court?
Of the Honorable High Court.
Page number?
At page, before I go there, in the second volume only, my lord, page 299, the High Court premised that order on this affidavit that it called upon me to submit. Page 299 in volume 2, I was called upon by the Honorable High Court to submit an affidavit because they complained that I was blocking their access or not permitting them to stay in the house. This is the affidavit that I filed. I am the sole and absolute owner of the property. My lord has that at page 299. And then I'll take my lord to the order. I am the sole and absolute owner of the property measuring 2 acres, 6 guntas bearing so and so, having purchased the same under registered sale deed of 2005. One on so and so plaintiff's father's request. I permitted him and his family to reside in the house towards the northwest corner of the Schedule A property measuring so and so, is more particularly described in so and so. Except for the Schedule B property comprising of the house in which so and so is residing, I am in peaceful possession and enjoyment of the remaining vacant land measuring 2 acres, 2 guntas in the Schedule A property, more particularly described in the Schedule C. After 29 years of litigation initially started by so and so and thereafter continued by the plaintiff's father, the Honorable Supreme Court in SLP so and so of 24 confirmed the judgment passed by this Honorable Court in RFA in my favor. Thereafter, on 5/12/2024, I deputed my workmen to widen the gate to the Schedule C property and to erect a fence for the development of the Schedule C property. Mr. So-and-so and Mr. Vishal Baliga, that is the plaintiff, along with his family members and certain other persons, caused severe disturbances and unlawfully obstructed my workmen from carrying out their activities. During the confrontations, the plaintiff's father fired a gunshot. Thereupon, the police came to the property, and after bringing the situation under control, the police registered 2 FIRs, crime number so-and-so. On 19/12, the plaintiff filed a suit.
Petition WP is not a WP CPC petition.
It's not a WPCPC. It is against the police.
That's what. Then the court said, you go before the trial court will deal with it.
That's right. In that order, my lord, will see at page 172 in the first volume. Page 172.
Yes.
Before that, 161, the prayer that was there before the court. 161, the prayer before the court, before this honorable court.
Yes.
Prayer, issue writ of certiorari quashing notice dated so and so. Second prayer, my lord. Issue a writ of mandamus directing respond numbers 4 and 5 to implement the order dated 15/1/2025 passed in OS number 1708, which is a suit here, by the second so and so so and so, by directing respond numbers 4 and 5, that is the police, to visit the spot, implement the temporary injunction dated so and so passed by the trial court and provide police protection to the petitioners as also their property. This is the third time the prayer is being asked. In the light of this, my lord, will see at page 175.
Yes.
Para 4 at page 182. The observations made by this honorable court.
Yes.
Shri so-and-so, the learned senior counsel who appears on behalf of the petitioners in writ petition number so-and-so submits that there cannot be any dispute about the possession of these petitioners because of the conclusion of the proceedings on the application for temporary injunction with the dismissal of the SLP so-and-so by the apex court. And the learned counsel is categorical that any question relating to possession or use must be decided by the civil court and the police cannot intervene. That is their statement recorded. These submissions must be considered in the backdrop of the submissions on behalf of the petitioners on 18/9/2025, that even as of today, their access to the subject property is blocked, and even if the access is open, their use of the residential property will be affected. In response, and in terms of the liberty that is granted by this court, the applicants have filed an affidavit stating that the petitioner's access to the residential property is not blocked. The affidavit in this regard reads as under, I so and so, that was the affidavit I read out. She so and so, when queried on the proposition relied upon by she so and so that the possession and use of the subject property must be examined by civil court, which is sees of the matter, submits that he cannot controvert the proposition. These submissions are taken on record, not to render any
How this
opinion
is
on the
res
possession of the
judicata
subject property.
according to the petitioner?
Pardon me, no?
How this order, how this is res judicata?
The reason this is res judicata is this prayer that was in IA number 3 was sought once again in IA number 3 was the first time that they asked for police protection. In response to that, my lord, the police submitted a report. The Kannada version is given. I'm just handing over the English translation. In response to IA number 3, where the court said, implement the order of injunction. The injunction order said, do not interfere. This is the report that the police submitted. With regard to the above subject and reference, I pray before this honorable court that on
No,
30th
this is a writ petition arising out of?
Which slowly, my lord. This is the order, this is a report submitted by the police in response to the order passed by the trial court in IA number 3. The first time the trial court said police to implement. The reason why I'm talking
That order, we'll see that.
that order. That order will, that was an ex parte order.
Yes.
At page 55. It is pursuant to this order that report came at page 55.
Yes.
Order IA number 3 allowed, issue direction to the SHO of the jurisdiction of the jurisdictional police to visit the spot and implement the interim order of the court and report the same, call on hearing date.
This is dated 25/4/25.
No, my lord, this will be dated 10/1/25. It is this is the first time.
Yes. Now let's see this order.
This report. This report, the police say, on 30th January 2025, we have received a copy of the order in OS 1708/2024 passed by the Honorable Senior Civil Judge and so on so from the plaintiff she so and so. On 1/2/2025, we inspected the place mentioned in the order copy, and in the said place, there is a residential house belonging to the plaintiff, measuring approximately 48 by 75 feet, surrounded by vacant space with two large trees and other plants. We found that the defendant in the said case is in possession of the remaining property. We issued a copy of the order passed by the senior civil judge and so on so to one Sri Chandrakumar, security supervisor, who was present there on behalf of the defendant, and instructed him to comply with the court order. Said Chandrakumar produced a copy of the order passed by the Honorable High Court of Karnataka in RFA 1664 and copy of the order passed by the Honorable Supreme Court in special leave so and so, and sailed it so and so, RTC so and so. In respect of the said case, complaints and counter complaints have been filed against the plaintiff and defendant in the Whitefield police station, and based on the said complaint and counter complaint, case has been registered in crime number so and so and crime number so and so. Those criminal proceedings have been stayed now by this honorable court. So those criminal proceedings have taken place. The nature of the property, my lord, is like this. It is a rectangular piece of property. In the northwest corner, there is a house. The rest of the property is vacant. In the northwest corner where the house is there, the plaintiffs are residing. It was their grouse before this honorable court in the repeated.
What is the sue schedule property of the partnership, the injunction suit?
Same.
Entire property.
Entire. 2 acres, 6 meters. Entire property. This court says grandmother herself as, plaintiff's grandmother in that case, defendant number 1.
In the present injunction suit, I'm asking.
The present, it is not an injunction suit. The present suit is a declaration suit based on the will.
Declaration suit.
Is a
In
based on the will.
declaration suit, she sought for an injunction. And the sue schedule property is the entire property.
She did not seek. The grandson sought. She is dead.
Whoever it is, whoever is the
Grandson.
plaintiff.
He sought an injunction in respect of the entire property, saying that I should not interfere. Police come and submit a report saying, interfere, no. He is in possession of this much. The defendant is not, plaintiff is not in possession of the remaining property. Defendants are in possession of the remaining property. Title is with me anyway. So that is what is reported to the trial court. Trial court does not act on that report, does not do anything further. The report is there with the trial court even now. Then they come before this honorable court with the same relief. That is the second time. My lord asked how res judicata. Second time at page 165, I showed my lord the order. This honorable court also says police will not interfere. While this was pending, third time, IA number 6 was filed, my lord. IA number 6 can be seen at page 164.
That is the present one.
Second one, the present one is the third one. Second one, when at 164, the IA is filed once again for police protection, the trial court itself says, I cannot consider this. Honorable High Court is considering. Therefore, I will not be and dismisses the application. Honorable High Court, when it is considering, says police will not interfere. All this is over. Then comes the third time, the application, IA number.
Here some clarity is required. As far as the High Court order is concerned, they have straight away come to the court under filing a petition under 226.
Yes.
Then the court has heard the matter and said, it is not for the High Court to decide. If at all they want, it has to be as per the circular in so and so. That's what it said.
That's all.
So nothing on the merits of the matter.
It did not arise out of the suit. I am only pointing out that the relief sought before
Then
the Honorable High
IA
Court
number
was
6. Please come to IA number 6.
IA
and the
number 6
order.
at page 164.
160.
164.
Yes.
For the reasons found in the accompanying affidavit, plaintiff most humbly prays that this honorable court may be pleased to advance the above case to this day for filing of application. Direct the station house officer, Whitefield Police Station, Bangalore City, to aid and assist the police to implement the considered orders of this honorable court on IA number 1 and 2 in the interest of justice and equity. IA number 3 was that complied with by the police. Now IA number 6.
What is the order?
This order, the rejecting this at 172. Peruse IA number 6. IA number 6 filed by plaintiff under section 151 of CPC praying to direct SHO Whitefield Police Station to assist the plaintiff to implement the orders of this court passed on IA number 1 and 2. Defendants filed objection. It is a duty of this court to implement its orders. Objections and contentions taken by the defendants are immaterial. Anyhow, learned counsel for defendants produced copy of writ petition
Anyhow,
of
this matter is pending before the High Court.
Correct. And this.
Yes.
Then this honorable court passed that order. Thereafter comes IA number 8, that is at page 187.
Yes.
Same prayer yet again. And no change in circumstances, my lord. Page 187. I'm sorry, that will be the second volume.
Yes. Then the order.
Then the order, my lord, is what I read out earlier at page 1919. 1919. Impugned order.
Yes.
Yes.
Yes, we have read this order.
This I read out. Therefore, my lord, I am before this honorable court to say that, and I will just 2 minutes, I'll take my lord through the citations also. The police have no role to play in a civil suit. At the best, if there is any law and order situation, which is what this honorable court also said, police to interfere. But police do not have any authority to evict a person. If I am in possession, I'm in possession. I have a sale deed, which is not even under challenge. My lord will also look now at the relief sought in the plaint. My lord is at page 30. The relief sought in the plaint does not even question my sale deed. Already the father and I have had litigation for the last 30 years. I have succeeded in the litigation. The son comes before the trial court, suppresses all these proceedings.
All these things are agitated before all the courts.
And up to the Supreme Court.
All these things, whatever you're submitting before the court, must have been agitated before all the courts.
Yes.
That's right.
But in spite of that, the court said you're restrained from interfering with the possession.
That's right.
So at this point of time, in this application, we cannot go into the petitioner's title and other things which were determined in the earlier suit. Now, there is an order of injunction, interim injunction that has attained finality, which presupposes that the petitioner is in opposition of the property. You're interfering with it.
That's right, my lord. The fact of the matter also is the police did come to the property and they have submitted a report, which is a statement of fact that I am in possession of the portion of the property. They are in possession of portion of the property. What in the impugned order the trial court does, you go and remove them. That is not permissible in law, is my submission on that, the citations.
Yes.
First one, my lord, that is 2004 SEC Online Bombay High Court. But at page 5, para 10.
I think, do we need to go into this issue?
But my lord, I may as well just point out whatever all these
Yes.
submissions are. It is
Para
well,
number 10, 13 and, yes.
10 and 18 also would be relevant. It is well settled principles of law that the principles of res judicata. My lord, on res judicata, this is the position.
Yes.
Lord, at para 18 also the same principle that on an interlocutory stage, res judicata will still apply. And my case is that res judicata applies because I number 1, I number 6, and then yet again I number. Because if at all they were aggrieved with the police report, they could have challenged it, saying that the police are not doing their job, the police ought to have taken something. They chose not to. They come before this honorable court with the same relief, I number 6 with the same relief, and then I number 8. Therefore, there should be some bar there. Lord, we'll see the second decision at ink page 12, 2004, 1 SCC 769. Here, my lord, was the issue of possession and dispossession. Para 6 at page 17. Para 6 at page 17. The law in India.
Yes.
The law in India as it has developed accords with the jurisprudential thought as propounded by Samand and Midnapur Zamindari. Sir John Edge summed up the Indian law by stating that in India, persons are not permitted to take forcible possession. They must obtain such possession as they are entitled to do through a court. But slightly further below in para number 7, law respects possession even if there is no title to support it. It will not permit any person to take the law in his own hands and to dispossess a person in actual possession without having recourse to a court. No person can be allowed to become a judge in his own cause. In the last paragraph on the same page, a defendant in such a case must show in himself or his predecessor a valid legal title or probably a possession prior to the plaintiffs and thus be able to raise a presumption prior in time. In MC Chokalingam, this court held that the law forbids forcible dispossession even with the best of title. In Krishnaram Mahale, it was held that where a person is in settled possession of property, even on the assumption that he had no right to remain on the property, he cannot be dispossessed by the owner of the property except by recourse to law. Now, the third citation at page 22, more directly on the point. Page 22, a decision of a coordinate bench of this honorable court, 17th February 2025, and writ petition 4740 of 2025.
Yes.
Ink page 22. I may request my lord to come to ink page 26, para 7.
Yes.
Ink page 26, para 7. The only grievance of the petitioner is that in the guise of implementing the injunction order passed by the trial court, the police are trying to dispossess the petitioner defendant from the suit scheduled properties, which is my apprehension. In that view of the matter, this court is of the opinion that the only direction that can be issued at this stage is to direct the Inspector of Police, Kadugodi Police, not to dispossess the parties who are in possession of the suit scheduled properties and not to alter the nature of the suit scheduled properties. Accordingly, the following order is passed. Inspector to do so and so. In the guise of implementing the order, he shall not dispossess parties who are in possession of the suit scheduled properties and shall not alter the nature of the suit scheduled properties. Next decision, my lord, at page 28. Again, another coordinate bench only. My lord, the relevant portion at para 5, page 32. Page 32, para 5. In so far as the prayer sought in respect of I number 4 is concerned, the application is filed under section 151 of CPC seeking police protection. The apprehension of the defendant is that instead of merely implementing the order, the police are supporting the plaintiff in altering the nature of the suit scheduled property. Then at senior counsel appearing for the plaintiff respondent submits that the police protection has been sought only to ensure that the order of the trial court passed on I number 1 is not violated by any party, and if the plaintiff will not make any alteration to the nature of the property with the aid of the police. In view of the above, no further orders are required to be passed on I number 4. However, it is clarified that the police shall extend protection only for the purpose of ensuring implementation of the trial court's order passed on I number 1 and shall not support either of the parties in making any alteration to the suit scheduled property. In the event of any violation of the trial court's order, the police shall report the same to the concerned court. I will only close by making this submission, my lord. It would have been a different position if after the passing of the first order by the honorable trial court, one of the parties had violated it and altered the position. Then, my lord, the trial court is definitely empowered in law to set right the position as it was on the date of the order. It is nobody's case that I was never in possession. I have been in possession earlier also. One of the writ petitions that has been filed before this honorable court by the plaintiff's father is prior to the suit. He says that I am in possession of the property. It is acknowledged by them that I am in possession of the vacant portion of the property. They are in possession of the house in the northwest corner. This being the possession, this is the law. Great.
It's much has been said about that police report. First, I'll deal with that police report. There's an order of ex parte injunction was granted at the first instance, for which there was an application filed seeking police protection. Police, instead of implementing the orders, they filed a report. Then this report was very heavily relied upon, like it was relied upon now, while the applications were being considered on merits. Page number 83 is the orders, because much has been said about this mischief on the part of the police. Page 83, the order dated 2nd June 2025. Now it's at page 95, which will be para 13. Because for a statement to be made that police report is still a part of the record not considered is something which is not commensurate with the records.
Yes.
Para 13, after that Canada portion, Milords, evidence was adduced in 2012 according to the defendants in the year 2005 through sale deed possession was delivered. In the year 2012, defendant number 1 in OS number so-and-so clearly admitted that he is not in possession of plain B schedule property. Admissions made by DW1 clearly falsify the plea of the defendants and falsifies the revenue records and shows possession was not at all delivered to the defendants. After ex parte injunction order, direction was given to the police to protect the interest of the plaintiff and to submit the report. Instead of submitting report, Inspector of Whitefield Police filed a report stating that the defendants are in possession of B schedule property. Video visual shows the velocity of the truthfulness of the police inspector who submitted the report and who went near the suit schedule property with the defendants, their supporters, and with the gundas. Further statements are made. So this is the manner in which the defendant has been in a position to meddle with the orders, notwithstanding that it has attained finality up to the Supreme Court. Now, the only other question which he has raised is this, that there is an element of res judicata. Lords, the first order stands that there is a requirement of giving police protection, that they have not challenged. That is what actually operates as res judicata. There was already an order directing the police to implement. Then the police says, no, we are not unable to implement. So court comments that no, the police is actually going along with their gundas for the purpose of ensuring that this is done. Now that is an order which has actually attained finality. After that, what happens? An order of injunction is granted by observing all these things. They come before this honorable court. Again, the same contentions are raised. This honorable court rejects their MFA. They go to the Supreme Court rejects the MFA. Then what happens? A 107 notice is issued at their instance. Then 107 proceedings is not required. When an order of injunction is already operating in my favor, we come before this honorable court and saying that you please pass an order. The court says, so far as the observations of 107 is concerned, you can't do it because there is a circular. When the matter is pending, you cannot take recourse to such proceedings. Possession protection is concerned, it is for the civil court to pass the orders. Then we go to the civil court and make an application. Civil court now passes an order saying that there is an order of injunction confirmed up to the Supreme Court. It's required to be implemented. This is in the teeth of the findings. As my learned friend has already relied upon the judgments, I'll not struggle myself to do that. The orders which says that they are not in possession and we are in possession of the property, that there is an order of police protection which was earlier granted, the police report having been falsified, and the fact that the matter is confirmed up to the Supreme Court operates as res judicata as against them. Where is any question of they coming before the court and now pleading that no, this order of injunction should be rendered specious by saying that the police protection should not result in this or that. The orders which has been passed by the trial court as confirmed up to the Supreme Court requires to be implemented.
No,
There's one judgment of your lordships.
No. Is it the case of the plaintiff?
Yes.
That during the pendency of the proceedings, they have dispossessed them?
No. We are in continuous possession of the property. There is a continuous act. We have the video visuals. Actually, what was demonstrated before the. As a matter of fact, even in the earlier round, we have demonstrated.
No, now the operative portion of the order says.
Yes.
There is that page number?
That is page number 19.
So, look at the operative portion.
Lordships.
At page 24.
It says,
To implement the orders of the court.
remove the obstruction placed by the defendants in plain pre-scheduled property.
Yes. Lords, when an order of
Where is
injunction,
that, where is that order? of
kindly have a
injunction?
look at the order, my lords.
No, no, order of injunction that is granted.
Lords, order of injunction that is granted originally is at page number 100 and 101.
101.
Yes.
Please come to that specific observation.
Regarding, my lords, the
Regarding the possession and how you are entitled for injunction.
Lords, kindly have a look at paragraph number 12.
Para 12.
According to defendants, they are in possession of the should be scheduled property, and to substantiate their possession, they produced RTCs. RTC extracts show that the defendant number 2 is in possession. It is well settled that revenue entries shall be presumed to be true unless the contrary is placed. In instant suit, contrary to the revenue entries were placed, contrary entries MR number so and so dated 14/11/2005 rejected to mutate the revenue entries in the name of Sheila Gopal because of non-production of GPA. Defendants not produced any documents to show how revenue entries were made in their name in MR number so and so. Apart from this, most important aspect is the video visuals. Video visuals are alarming and the shame on the society. Visuals show that somebody destroyed the compound wall with the help of JCB. Around 50 to 60 goons entered into the property. Police were present at the spot but failed to take action. Instead of taking action, the police supported the goons. Even though the gundas assaulted women, police kept quiet. Visuals also show one of the persons who has to protect the law was supporting the gundas. Visual shows that the fraction of seconds entire topography of the B schedule property was changed commonly. This kind of visuals will be available seen in Telugu movies, but in the instant suit, such visuals are available. It is shame on mankind and shame to police. Police requires to protect the rights of the parties, but the police have the gundas entered into the property in a cinematic manner. Their behavior is very worse. Visual shows the defendants on the strength of the salients trespassed on B schedule property with the help of police and gundas. Gundas destroyed the compound wall. Gundas assaulted women in front of the police. Gundas' behavior was very bad and rude. These visuals shows that the defendants is not at all in possession by creating revenue entries on the strength of revenue records trespass the B schedule property. Learned senior counsel appeared for the defendants, not submitted anything about these videos. Apart from this, the DW1 in OS number so that is defendant number 1. The DW1 is the petitioner in that suit. That is defendant number 1 in the instant suit. In his cross-examination at page number 11 in the deposition deposed that Dawa Swattu Namma Tayi Hagu Sadri 14 jana ಕ್ರಯದಾರರ ಸ್ವಾಧೀನದಲ್ಲಿ ಇಲ್ಲ ಅಂದರೆ ನಿಜ. Essentially meaning, lords, that the suit property is not in possession of either the mother or the 14 persons who had executed the sale deed. That suggestion is true. Evidence was adduced in the year 2012. According to defendants, in the year 2005, though the sale deed possession was delivered in the year 2012, defendant number 1 clearly admitted that he is not in possession of the plain B schedule property. Admissions made by DW1 clearly falsify the plea of the defendants and falsifies the revenue records and shows that possession was not at all delivered to the defendants. After ex parte order, this portion I have already read to your lordships, I will not be repetitive. Now your lords may kindly take the orders passed by this honorable court. At page number 103.
No,
Para 2.
No. Before that, we'll read at page 100.
Which one, lords?
100, page 100.
300.
100.
These points involve visuals clearly show that defendants with the help of gundas trespassing on B schedule property. Defendants are also admitted that they entered into agreement with Karnataka soaps and detergents to cut and remove the trees in B schedule property. If injunction is not granted, defendants will be thrown out from the B schedule property. Defendants will change the entire B schedule property within no time. Acts of defendants shall be condoned. Acts of police shall be viewed seriously. This is a classic case for illegal acts of police and gundas. If injunction is not granted, definitely defendants will dispose the plaintiff from B schedule property and they will cut and remove the trees of the B schedule property. On the other hand, if at all the defendants have any right, they have to take possession according to law. Their behavior is not proper and they cannot enter the B schedule property with the help of goons, with the help of police.
Finding of the court is that defendant, the plaintiff is in possession.
We are in possession of the property. They are trying to interfere with our possession of the property by taking recourse to all acts, deeds and things.
Yes.
Now, what contentions were raised before this honorable court in the MFA, page 103?
Yes.
Lords, the same contention, my lords, paragraph number 3. They again said the same thing.
Yes.
Last 4-5 sentences in page 106. He would submit that the learned trial court has committed a grave error in believing the video clip produced by the respondent alleging that there was an attempt of disposition of the plaintiff from the suit property by using antisocial elements with the help of police. Repeatedly, the respondent is submitting about the alleged high-handed act of antisocial elements police to help the appellants, which is not true. Learned counsel for the appellants relied upon the observations of the trial court, which according to him are erroneous, in addition to the grounds urged in the appeal, so on and so forth. Now, this is essentially the ground which they had actually raised. Then, para 4, my lords, having considered this, then paragraph number 6. Lords, they were claiming on the basis of a sale deed executed by the power of attorney holder of a dead person. It's essentially, my lords, where the entire dispute stood. This was completely on perusal of the impugned order at page 115, paragraph number 10. Lords, after having discussed this entire thing, if your lordships may also have a look at page number 114 regarding that videos and all, my lords. About 6-7 lines from the bottom at page 114. The respondent in turn has placed on record numerous documents to demonstrate his continuous possession, including residential documents and electricity bills. Even the appellants also admit that respondent is residing in the house with his family, but it is with their permission. Most crucially, CCTV video footage is observed by the trial court in the course of the order show that appellants, along with the group of persons, including police officials, trespassed to the property, broke down the compound while using JCBs, intimidated the residents. In the course of the order, the trial court has remarked the visuals of in the video clip as disturbing, condemnable, and there was an attempt of disposition which must not be condoned in civilized society governed by rule of law. And perusal of the impugned order, the learned trial court has examined the pleadings documents placed on record relevant legal principles, including the scope of grant of temporary injunction 39(1) and 2. Also concluded that the threshold, whether there exists prima facie case, balance of convenience, tilts in favor of the applicant, irreparable injury will be caused, has been applied to the trial court in its full breadth. The trial court has rightly concluded the plaintiff has established a strong prima facie case, particularly on account of his uninterrupted possession, expressed grave doubts surrounding the GP and sale deed. Balance of convenience lies as the trial court is preserving the status quo rather than appellants to take law into their own hands. Irreparable injury is manifest, especially considering the acts of destruction and risk of permanent deprivation of possession. Considering this fact, the trial court has passed the impugned order. Another contention, the appellant lacks jurisdiction, my lords. I will not trouble your lordships. Ultimately, the appeal is dismissed. And Supreme Court's order, my lords, is at page number 119.
Yes.
We have heard the counsel for the petitions having considered the contentions made across the bar. 119, my lords. We do not find any reason to grant special leave to appeal. As such, the present special leave petition is dismissed. We direct the concerned court to expedite the trial.
Yes.
Lords, after this, since Lords, now the court passes an order of injunction.
Supreme Court order is dated?
Lords, the Supreme Court's order is, Lords, it is dated 1/8/2025. Then comes this writ petition because 107 proceedings came to be initiated. After this writ petition is filed, the coordinate bench of this honorable court said that so far as the orders of the courts are concerned, the last paragraph, it is specifically observed that the orders of the court is required to be complied with by the courts, and the civil court will have to take action. At any rate, police, there is a circular, you cannot do anything more than that. The reason why this was necessitated was because the manner in which the police had colluded with the defendant. Even now, this is the problem. Despite there being an order of police protection, police did not protect. There is an order of injunction confirmed up to the Supreme Court, the police do not come to the aid. Now we have made an application, my lord, seeking an order of police protection. And after this, there is a letter dated 2/3/2026, which is addressed, my lords, to because the intimation has to be given to the concerned police station. Even this intimation is given. There appears to be a lot of high-handedness, my lords, on the part of this defendant who somehow is hobnobbing with this entire issue with the help of the police and the gundas. And that's a finding which has reached finality up to the Supreme Court on a finding, my lords, that we are in possession of the property. Ultimately, my lords, what the trial court has directed is, there is an order of injunction which is granted. So that injunction has to be implemented in its full perspective. If there were any change in circumstances, it was for them, my lords. There is one judgment of your lordships, my lords, while presiding in the High Court of Telangana, very exhaustively considering, my lords, the principles as to grant of police protection. Para 31, my lords, in where your lordships have concluded. para 30, para 30 minutes, more or less like. There is no dispute about the fact that for execution of a decree of a civil court, the decree order is a remedy to file execution proceedings. At all times, it should be the duty of the constitutional court to uphold the rule of law and the fundamental rights of the citizens. Defendant in the suit and the respondent herein has conveniently taken the process of the court for a right, though the court is not giving findings that in each and every case, whenever there is violation of injunction order, the remedy of the affected parties to approach the court. In this case, where plaintiff and defendant both are before the court and court having observed the conduct of the defendant in this type of case, if the police protection is not uttered, people will lose hope on the judicial system. More or less the same facts which was before the court. So therefore, my lords, my respectful submission is that the orders of the court which has reached finality up to the Supreme Court has some sanctity. It requires to be implemented. There may be right or wrong orders, but once the orders have attained finality, that requires to be implemented. That's essentially the principle of rule of law, my lords.
Just two submissions.
Yes.
In the injunction order that was read out of June 2025, where the trial court says that the GPA appears to be doubtful, video visuals are there.
High Court.
Those video visuals that are being referred to are referring to an incident much prior to the suit. That was on 5th December when I went to erect my fence. And that is when they opposed me. They fired a gunshot. Those proceedings were relied upon by the trial court without appreciating the fact that all those proceedings have been stayed by this honorable court at their instance and at my instance, because there were complaints and cross complaints.
We cannot look into all that.
No,
We can
the
only
fact
look at the
Against the
order.
counter FIR, my lords. It
The
will not have
clarification
any-
has to be from the
They
order.
have to be, yes.
All that I'm submitting is this: the material relied upon by the trial court was not contemporaneous with the suit. It is prior to the suit which has been stayed. Therefore, that is not correct
But
material.
unfortunately, those are the findings which attain penalty.
That's
Then
right.
this-
For the High Court and the
So-
Supreme
Well,
Court.
so
No, but it's not open
nobody
for-
has given a finding that I have trespassed into the property. That
is
finding is
nothing.
not there. If at all, and last, I will only leave it at this. If at all it is the case of the plaintiff that they were in possession and I have dispossessed them forcibly, the remedy of a normal plaintiff would be a section 6 suit. That this is my title, I am in possession, I have been dispossessed. Therefore, under section 6 of the Specific Relief Act, I seek to be put back in possession. That is not the case of the plaintiff. The plaintiff nowhere refers to anything. All that the plaintiff refers to are questions that are already settled in RFA. But this is just 30 years of litigation. After 30 years of litigation and coming to categorical findings on validity of my sale deed, validity of my possession, grandmother having executed the sale deed in my favor. Looking at the plaint also, my lord will see, none of those proceedings are brought before the trial court. Only video visuals, gundas, police, none of which are available to the trial court to consider also. And even as, this is my last statement, even as of today, I am in possession to show that 50 cars are placed there. I've given it out as a parking lot to a neighboring company there. They are using it as a parking lot. My cars are there, my
Entire thing,
vehicles
what
are
I
there.
am not able to understand is, when the court gives an injunction, giving a prima facie finding about their possession, how can this court will record contrary to that?
The
Or
only-
how can you submit contrary to that?
We cannot go on like that. I only one answer. The doubt
I would put
I'll
it
make
this
the
way, my
submission.
lords.
I'll make
The
the submission. Let me
Brazen
just-
submission-
No, let me
Let
make
him-
the submission and end it. Your lordship is saying, there is an order of injunction. What can this court do? Absolutely right. The question staring at this in the face of the court is, once the order of injunction came, is there any material to show that the defendants have subsequently violated? If that is a finding, I will bow down to this. That is the only thing. Subsequent to the injunction order, if there is a violation, I cannot have a legs to stand on before this honorable court. 30 years of litigation, and this is the fate of litigants.
Just a brazen submission which was made saying that we are still parking the cars in the vacant space. Speaks volumes of the fact that they have scant respect for the orders of the court. Prestige
Take
Lights
that.
case says, my
Synopsis
lords,
of dates and events.
that
With
they don't even have a right of being heard, where they have the courage to come and make a statement, we are violating the orders of injunction. Grateful, my lords.
And today, my lord, in
Third.
spite of the direction, Ravi, last submission,
I-
in spite of the direction of the Honorable Supreme Court to expedite the trial, I said, all right, expedite the trial. Pleadings are complete. Now they file an IA for amending the suit, completely changing the nature of the suit itself. New
the
reliefs
merits-
are sought to be added. So
Heard,
that is-
reserved, orders on Thursday.
Lordship's grateful.
57, OJ3 for petitioner, Suman Naganan for R112.
May I please this honorable court? My lord, the petitioner before your lordship
receives an OC for 11 residential apartments in the year 2006, and this is in the city of Mangalore. My lord, one fateful day in,
What is the suit
my
for?
lord, it is a KB matter. The list is against the MESCOM.
This
I
is
appear,
50?
my lord.
7, my lord.
I appear for respondent 1 and 2, my lord. Objections are ready.
My lord, I
Served on
have,
him?
I'll serve, my lord.
my lord, I have a few submissions to make. In the year 2013, in an alleged
You
raid,
have an interim order in your favor.
no, my lord. What has happened is, I might be fait accompli at this point. What I have actually specifically challenged in this matter,
7400 says interim order is there.
There is no interim order, my lord.
there is no interim order.
Because as a matter of fact, my lord, because the arrears were not paid,
Because
it's
my,
been
the whatever,
disconnected.
When was interim order granted? Then why is it, why the order sheet shows that it's extended? Give it. Oh, when it is happening? First time when it was done. 1 minute. It was on 22/4/2026. The request of Plan Council, this is matter in the first list. This Suvarna has done it. 25/6/2026. Delete this portion and upload the order on 25/6/2026 order. 20 next from there on all the orders. Yes, argue. Yes.
2006 is when I received the OC to 11 residential apartments, my lord.
Yes.
This is in the city of Mangalore. Annexure A is the OCI.
What is the relief you are seeking in this?
My
application?
grievance is this. 2013, there is a raid that happens. The MESCOM comes to the conclusion that I am running a service apartment, hence I am liable to be penalized. My lord, subsequent to 13 years of litigation, 2025, this honorable court sustains
No,
the penalty.
your power supply
My
is
lord,
disconnected.
2018 is since when I don't have a power supply. My
2000?
My lord, there is a series of letters at Annexure B. 2018, my grievance starts. Is when power is disconnected, my lord. 2018 to 25 is when the litigation persisted. My lord, my grievance now is, now after the litigation ended insofar as the raid, they serve me a termination notice. They're forcing me to pay commercial tariff. My lord, I am a residential apartment. I'm in a residential zone. Now, there is one.
What is the nature of activity? What is for what purpose you are using it?
It is an apartment complex. It is an apartment building. When the raid happened, they said I was running a service apartment there. That was what was under litigation for 13 years, my lord. Then subsequently penalty was upheld. On the date of the raid is when they say I was running the service apartment. My lord, now they're forcing me to pay commercial tariff for the period I never even had an electricity connection. Now they serve me these notices, which I put under challenge before your lordship. They say I am arbitrarily due to them a sum of 16 lakh
No,
rupees.
now in this writ petition, is it your case that from 18 to till now, they're
I don't
demanding
have
the-
electricity, my lord.
They are demanding the.
Please, they have
amount.
already forced the day before yesterday, my lord, they transferred whatever was under challenge here to another building of mine, which had rented out to a pharmacy distributor. They were very well aware of that. They show up at another premises, my lord, and take a check from me for the sum which is under challenge before your lordship. My lord, they threatened disconnection. Section 56 of the Electricity Act is very clear. They had to serve 15 days of disconnection notice, even if the arrears were transferred to another building of mine.
Yes.
I am the distribution company, my lord. He has 11 apartments where it was built
No,
as
you
a
have
residential.
disconnected the power supply in 2018.
No, my lord, I'll point out, my lord, this is the 5th round of litigation. He has suffered 4 orders which has been confirmed by the Honorable Division Bench as recently as 2025, my lord. He has produced it with a memo. I'll just briefly, my lord, explain the facts, my lord, that will make it clear. He has 11 residential apartments, my lord, for which he had been given LT2A, that is a tariff applicable for residential premises, is what was given to him initially. In March 2013, my lord, my vigilance wing goes and does an inspection and they find that it is actually not being used for residential purposes. It's being used as a service apartment. Under the tariff order of the KERC, my lord, service apartment comes under a commercial category for which a different tariff is applicable. We issue notices, my lord. He challenges that, goes before the appellate authority. Appellate authority passes an order. He challenges that in a writ petition. The Honorable Single Judge then says that, you give him opportunity of hearing and you redo this process. That process is done. Then one more round goes before the appellate authority. Appellate authority confirms, my lord, the back billing charges, which is challenged, my lord, in one writ petition. I'll just point out, my lord, two orders, my lord. It makes it very clear that this is something that has been.
Where are your objections?
These orders, my lord, my learned friend has placed with a memo of 22nd April 2024, my lord. There are 4 orders. I won't trouble the Honorable Court with the first 2 orders, my lord. I will only go from the 3rd order, which would get at page 19 of that memo. That is the order of 24th April 2025 in WP 19895 of 22. This was a challenge to the second round of appeal where the back billing charges was determined at approximately 16 lakhs. That is what was challenged here. Facts, paragraph 2, page 21. This petition is filed assailing the order dated 22/7/22 passed by the 3rd respondent appellate authority in annex, in terms of which the order dated 11/10/21 passed by the assistant executive engineer R2 is confirmed. In terms of the earlier demand, petitioner was directed to pay 16,23,656 towards back billing charges. The impugned order at Annexure B directed the petitioner to pay 4,36,000 so and so, excluding the amount of so and so already deposited out of the tune of 16 lakhs so and so. The order dated 11/10/21 passed by the second respondent is confirmed by the appellate authority. The brief facts are as under. This, my lord, would be of relevance. Petitioner claims to be the owner of a residential apartment known as Home Space Apartment, comprising of 11 residential units in Mangalore. The competent authority had issued permission to construct residential buildings in the apartment. Likewise, electricity connection was obtained for residential use, which attracts LT2, that's residential tariff. Petitioner claims that the flats in the building are being used for residential purpose by the tenants under him who have taken the premises on long-term lease basis. Vigilance Squad claims to have inspected the premises on 15/4/13 and it is alleged the premises was found to be used as service apartment and according to the respondents attracts LT3 tariff, that is a commercial tariff. Vigilance Squad claims to have recovered certain documents and claims to have prepared a MASA at the time of inspection. First respondent on so and so issued notices to the petitioner demanding electricity charges, applying LT3 charges, that is a commercial tariff. Petitioner says that he has applied under the RTI. All that, my lord, may be skipped. I won't trouble my lords with that. If I may invite my lords to, from paragraph 18 onwards, my lord, page 30.
You can come to paragraph 18.
Please, my lord. On considering the affidavit referred to above, it is very much evident that the structure and the paragraphs and the videograph produced by the respondent are owned by the petitioner. He was called upon, my lord, in the earlier round.
Yes, I've read that.
Please, my lord. The building does not belong to any partnership firm. The petitioner in his petition also stated that he is the owner of the home space apartment. This court has perused the videograph produced in the pen drive. On perusal of the said videograph, it can be certainly inferred that the premises is not in occupation of tenants as claimed by the petitioner. During the visit, none of the tenants were found to be in occupation of the premises. Certain features appearing in the videograph would clearly suggest that the premises was not in use by a long-term user like a tenant. The feature captured in the videograph as well as the photograph suggests that the premises was used as a service apartment. Some of the sign plates like do not disturb, clean the room, leave the towels on the rack, so and so, are noticed in the videograph. It is relevant to notice that no tenant is examined on behalf of the petitioner to prove his tenancy. This court takes the view that the premises was not used by tenants, keeping in mind the defense raised by the petitioner that the petitioner has let out the premises to the tenants on a long-term lease basis, which is not established by leading the evidence. Then, my lord, paragraph 23. It is also relevant to note that except those documents which are inadmissible in evidence for want of registration, he, my lord, tries to place on record a lease deed which is not adequately stamped. So they refer to that, my lord, and then this is the finding. It is also relevant to note that except those documents which are inadmissible in evidence for want of registration and for want of payment of stamp duty, no material are placed to hold that the property in question was let out for residential purpose. It is relevant to bear in mind that the petitioner has not claimed that the premises were vacant or unoccupied. It is not his case that he was using the premises for his individual use or used by his family. The defense is that the petitioner has let out the premises in favor of the third respondent for residential purpose. When the said defense is not established, the inference that can be drawn from undisputed photographs and videograph would be that the premises was used for commercial purpose at the relevant point of time. Though it is urged that no documents and no articles were seized at the time of spot inspection.
I've seen. So the
Please,
court
my
has directed him to pay the amount.
Yes, my lord.
It is
Thereafter, my lord,
4,13,000 rupees.
kindly let me finish. Thereafter, my lord, paragraph 30, my lord. In the facts and circumstances already discussed, it is not possible to hold that the premises were vacant or under any personal use of the petitioner, as such defense was not raised at any point of time. Under these circumstances, more particularly in view of the admission relating to the photographs and videographs, this court does not find any reason to interfere in the orders passed by the competent authority and appellate authority, which has concluded that the premise was used as a service apartment. Given the fact that the photographs and videographs are admitted in the spot inspection is also established.
Yes.
Hence, the finding with regard to use
Yes.
has to be inferred. So they go on, my lord, to operative portion, paragraph
Then he
30.
was directed to pay 4 lakh.
That direction is to pay the amount that has been upheld by the appellate authority
In respect of the entire building.
in respect of those 11 apartments of approximately 16 lakhs, my lord, page 41, my lord, Roman 2.
I saw that.
Petitioner, yes, within 45 days, he has to pay that along with 6% interest from the date of the impugned order. This, my lord, was challenged by him before the division bench. That is the next order. 13th of October 25 in writ appeal 922 of 2025. Paragraph 2, my lord. The relevant facts in a nutshell leading to the present appeal is there's a reiteration, my lord, of it was alleged that the appellant was using it as service apartment and hence attracts LT3. Notices were issued demanding LT3 electricity, so and so. Thereafter, my lord, the last but one page, internal page 7, the third sentence from the top. It is forthcoming that the original authority, after appreciating the material on record, has held that the premises in question was being used for commercial purpose, while the electricity connection was taken for residential purpose. Hence, the total demand of 16,23,656 was raised. After deducting a sum of so-and-so deposited by the appellant during litigation, appellant was called upon to pay the balance sum
Yes,
within
yes,
30
it
days.
is affirmed.
Yes, my lord. Thereafter, the Honorable Division Bench at para 13
So
says, my lord,
according to
that
you, with respect to all these, the entire apartment under use, this order has attained finality.
yes, my lord. If the Honorable Court
What
would
is
just
the, what
look
is
at
the present
prayers, my lord.
present relief is seeking?
Exactly, my lord. Prayer is at page 27. There are 5 prayers that I have sought for. First is a challenge to the termination notices.
1 minute.
Please, page 27.
Hmm.
Prayer A is challenge to termination notice. These termination notices are issued in furtherance to the orders which call upon him to pay. He is not paid.
Hence it is issued.
Yes. So we've issued termination notice to say if there are arrears, you are required to pay. You've not paid, hence we are terminating.
Yes,
That is
next,
prayer 1.
next.
Prayer 2 is to restore electricity for those 13 installations under LT2A, that is residential. That insofar as that period is already settled by the division bench, that it can't be
It's a
residential.
commercial one.
Yes, yes. Prayer number 3 is to direct the respondents to withdraw all the bills raised for
So how
those-
can he raise it when it is already attained finality?
Yes, my lord, that is my case. That is what I've said in my objections as
Next,
well.
4th.
4 is that we cannot compel him to pay LT3 commercial. The tariff order categorizes the use of
No,
electricity.
that is order of the appellate authority, which is confirming that it is-
Confirmed by the division bench.
that is where again the learned
Yes.
single judge and the division bench.
Yes, madam. What
Yes,
he
next.
says now is that you can't compel me to, you can't charge me at commercial tariff by compulsion. I'm using it for residential, but there's already a finding against him
Yes,
that it
yes,
isn't.
next.
So that is prayer number D, my lord. E is to direct the regulator, which is KERC, to consider which is the appropriate tariff. That, my lord, the commission's order is very clear. It has different categories. In what category? Service department, residential, commercial,
No, for
industrial.
example, now he'll stop using it for the commercial purpose.
Then we'll bill him at residential tariff.
My entire
There's
case.
no
ma'am.
difficulty.
That is my entire case.
The tariff applicable is entirely based on the purpose for which electricity is used. So if he uses it and is able to show that it's only going to be used for residential, we'll charge him at residential tariff. That is prayer
This
E,
is
my lord.
a point that they considered only
There
now,
are
my lord.
some more, no, I think
That is
it.
all, my lord. Insofar as
This
the
was a point that
interim,
was considered to only now, my lord. Now, my case is this. One fateful day, I had put it to
Forget about
use.
all that.
Well, that is all settled.
Don't go to all that.
Well, that is all
Can
settled.
is it open to you to raise all these issues?
Please.
The teeth of the order passed by the appellate authority, confirmed by the single judge and affirmed by the division bench.
Lord, I concede to all of those orders. My case is
Come
only
to
this.
first,
Well,
come
the
to your
due
prayer.
that was
Come
liable-
to your prayer. I
Please.
will hear you.
Please.
You first clarify.
Please.
Now first your prayers. They are quashing and setting aside the 13 termination agreement notices dated. These notices dated 9/1/2026 and batch are pursuant to the order of the division bench.
No, my lord. It's very arbitrary in the way that they don't say what I am liable for. My lord, what I was liable to pay per the terms of the division, honorable division bench's order was only 4 lakhs.
Where did the court say?
My lord, it is at page 49, my lord.
Please come to that.
My lord, total demand was 16,23,000. I had already deposited 11,87,000 while I was contesting and litigating for the last 13 years. My lord, I was only challenging 1 day's penalty order for 13 years. 2018, during the pendency of all this
If you
litigation.
file a writ petition of this nature and this kind of relief,
My lord,
do you expect that your client will get any relief?
my lord, my only grievance is that they're forcing on one fine day. I
Can
might have
anybody
been found.
understand from your prayers that that is your case?
My lord, my only grievance is this. My lord, the termination notices are very arbitrary. In fact, the division bench, honorable division bench, when it gave its order, said I was only liable to pay 4 lakh rupees. Termination notices were served of 16 lakh rupees. My lord, I had no other recourse. And subsequent to termination
When
notice,
the notice is given,
please,
are you not supposed to submit a reply to
I
this?
have, my lord.
Then where is the reply?
Please. Well, subsequent to these termination notices, now they come up with the sum saying I owe them 16 lakh rupees. I have produced one more memo, my lord. This transpired after I filed the writ petition.
After file. I'm not asking anything after filing.
Please.
When you receive the termination notice.
My lord, I
according
directly
to you-
challenged them.
According to you, the calculation is wrong.
I directly
Then-
challenged them.
Then if you bring it, because you do not want to settle the issue.
My lord,
That is not the
my
conduct of the
contention.
party.
My lord, I've already paid 16 lakhs that they had demanded
What
under
is your,
protest.
what did you say in your objections with regard to this? That he, according to him, even according to you, it is 16 lakhs.
yes.
He says he paid about 11 lakhs during the pendency of these proceedings. So what is now, whatever 11 lakhs and all, the outstanding is only 4 lakhs.
No, my lord, it's, what he's now saying is, so the way it works is, it was disconnected power. But although he was not consuming electricity, there is something called a fixed charge which continues to be levied. It is a charge that the ESCOM levies to
How
keep
much?
that available, my lord. All that put together,
Where did you say so?
in my, I'll point out. my lord.
You file your reply to this objections.
My lord, I have been rendered fait accompli day before
Huh?
yesterday. I have been rendered fait accompli. Day before yesterday, they forced me to pay 16 lakh rupees, which I have deposited, my lord. They transferred whatever was due here to another building of mine, which actually had a pharma distributor. So I could not afford the electricity to
So you
go.
have paid.
My lord, I have paid. But the thing is, they had to serve me a 15 days disconnection notice. They have not done. What the engineer does is show up at my building, says I'm disconnecting the electricity. I paid the sum which was under
your-
demand.
that
I might
will
have to
consider-
amend my writ petition, my lord. But now that I have exhausted their claims, let electricity be resumed under the residential category, and I will file an affidavit to that effect. I will
Now, Now, what is the course open now? Now,
If he wants to-
No, he has paid that 16 lakhs, whatever he has questioned
Yes,
before this
according
court.
to us, my
Anyhow,
lord.
in the writ petition, we have to see
Yes.
whether how you have arrived at that 16 lakhs. That
Please.
is a different aspect.
Yes.
Now, after paying all that amount, you have to restore the power supply.
If he makes a requisition for restoration, we are willing to consider, my lord. I have a universal supply obligation, I have to give him power. But he has to specify that I am going to use it for this, and I'll bill him as per that.
How much time you require for that?
As per the regulation, my lord, whatever.
It's
time is
already there. He
prescribed,
has a.
Let
no,
him make an application forthwith, my lord. Within 4 weeks, we'll consider it, and if earlier, we'll give it. There's no difficulty.
weeks, madam.
But that
2
would
weeks,
all be, my lord, subject to compliance with all the regulations. That's all.
I will strictly run, I will let.
Pending consideration of the respondent
Sir.
has filed their objections. Then counsel for the petitioner submits that as it was as the respondents were resorting to disconnect another power connection of the petitioner, he had to pay an amount of rupees, keep it, an amount of rupees 16 lakh,
7,400,
7,400 under protest.
please.
It is submitted that now having paid the entire amount, there may be a direction to the respondents to restore the power supply under the, what is the category?
Residential LT2,
Residential
madam.
category. Then counsel appearing for the respondent submits that petitioner earlier was using the premises for a commercial activity. Now, if the petitioner wants to use it for a residential activity, as per the regulation, if he makes an application to the respondents within 4 weeks from the date of the said application, they'll consider the same and pass appropriate orders.
Please.
Liberty to amend the petition.
Hmm?
Liberty to amend the petition.
Petitioner is at liberty to amend the petition. Does this matter in the month of September?
If, not another observation that they would be obligated to restore power connection notwithstanding.
Lord, in terms of the regulation, I
madam.
will do whatever has to be done.
The petitioners have already collected, the respondents have already collected the consumptions charges due as such they have to consider the petitioner's application and shall restore the power supply.
Deeply obliged.
Case number 58, Krishna JC for petitioner. Joshua Hassan Samuel for respondent.
Lordship, please, I appear for the petitioner in whose favor the interim order which is now being sought to be recalled. After my learned from that, sir.
I filed an application for vacating the interim order. This is a matter. There is a joint development agreement.
What is the suit for?
Let's, there's no suit, my lords. This is
This
section
is-
9,
It's a CPC matter.
but it's a section 9
Oh, section, arbitration.
arbitration.
Hmm.
Let's, I'll just give the list of dates, my lords, just for the purpose of, there is a joint development agreement. Under that joint development agreement, there was a dispute. Matter goes for arbitration. The arbitral tribunal, the majority award, grants them the relief. And pursuant to that, I challenge it under section 34. Once I challenge it under section 34, the 34 court sets aside the majority award. They come before the commercial division, appellate division of this court. They file 2 commercial appeals. That they seek for some interim reliefs in one of the petitions. Matters still pending before the court. In the meantime, they file an application. There is certainly a public notice comes saying that out of the 5 owners with whom I had contracted,
Out of the,
out of the 5 owners whom I had contracted under the JDA and who were parties to the proceedings in the arbitration, 3 of them said they are going to sell the shares. I lodged my protest and I said, since the award, majority award has been set aside, I am entitled to proceed with the construction. I am ready and willing. But despite that, what they had done is they wanted to proceed. So therefore, I invoked section 9 of the Arbitration and Conciliation Act. I went before the court the commercial court. The commercial court granted me an order that is there in the writ petition itself. I will take this court to page number 20.
Yes.
The court has made, the court has heard the learned counsel for the applicant. On the basis of the JDA, the respondent herein has invoked the arbitration clause. Arbitral tribunal came to be constituted. Having heard the matter, the learned arbitral tribunal passed an award, thereby allowing the claims of the respondent and rejecting the counterclaims of the applicants. The applicants questioned the said award before the commercial court and so on. So, and the said court had heard the matter, allowed the petition and set aside the arbitral award. Feeling dissatisfied with the said order, the respondents have filed COM AP number so and so before the Honorable High Court of Karnataka. Since the arbitral tribunal has already been set aside, arbitral award has already been set aside, it is deemed that the JDA dated is still subsisting and the parties to the said agreement shall adhere to the clauses. The applicant alleges that they are in actual physical possession over the disputed property. On the basis of the advertisement given in the newspaper by the prospective purchasers, the applicants apprehending that the respondents may alienate the application scheduled property. In order to protect the property in dispute from being wasted or alienated, it is hereby directed both the parties maintain status quo with respect to nature, possession, and title until further orders. Because all of us were put on note of this interim order. They said all of you all maintain status quo.
Now, let's see the interim order. When is it granted?
Well, it's this interim order.
Here. by
Yeah,
this-
Malabs, yes. Malabs, just one more thing, Malabs, I'll just take. It's good. Since the respondent 1 and 3, has my lord got it?
Hmm.
Since the respondents 1 and 3 have voluntarily appeared through their advocate, there is no need to issue notice.
Respondent is this petition.
1 and 3, 1 to 3. I think my learned friend is appearing for 4 and 5.
I'm for
4 and 5. Issue notice to respondents 4 and 5 through speed post, airmail and email. On the request of the advocate for respondents 1 and 3, matter would be called on 26/3 since he has expressed his intention to make submissions on that day. My lords, on 26/3, my lords, over the page, at page number 22. Counsel for the applicant and the respondent 1 to 3 are present, heard both sides, call for hearing and await notice of respondents 4 and 5. Well, let's come with me down. Advocates for the applicant and respondents 1 and 3 are present. Mr. So-and-so files memo of undertaking for respondents 4 and 5 and requested the court to grant time to file these objections to the main petition. Advocate for the respondents numbers 1 to 3 submit. He does not wish to file objections to the main petition or to the pending IAs. He requested the court to take up the matter for final disposal. He filed a memo citing 3 decisions. Matters thereafter, it has been posted. He comes here before this court, files his petition, obtains an interim order. Only one person out of respondents 1 to 3, only one person comes before this court, obtains an interim order. We were not aware of it because if at all he had to go before the commercial division because under section 9, an appeal will lie. Under section 13A, an appeal will lie. Thereafter, we get to know he has presented a sale deed for registration, all 3. The other 2 are in contempt. I've already issued a contempt notice. They have presented a sale deed and the registrar refused to accept it on the ground that all 5, since there are 5 co-owners and the revenue records stand in the name of all the 5 co-owners, he will not take there is no provision for accepting the document for registration. They file a writ petition. That is pending before this court. I have filed an application for impleading there. Thereafter, I have also filed a writ of prohibition. Plus, I'm only trying to say this. Today, your remedy was not before this court, and this particular petition is nothing like an order 7 rule 11. Well, there is a judgment of the Supreme Court. I'll just place it before this court, wherein the same question was raised. The question was framed as to whether a 227 is maintainable in respect of these matters when there is a remedy. Right, madam.
No, it is settled law. When it goes to the
Yes,
very
yes.
jurisdiction of the arbitration and all, then the court will entertain under 227.
No, madam, what it says here, limited.
Limited. That is settled law. We don't have to
Settled.
read it.
No, I'm only trying to say, Can the High Court in exercise of its supervisory jurisdiction under Article 227 reject a plaint? Basically, what he has contended before the trial court was that the court had no jurisdiction under Section 42 of the Arbitration Act, which is wrong. 42 only says which is the court which will have jurisdiction. If I'm approached a court at the first instance, that is the court which will have jurisdiction for all other purposes. That was a wrong provision which he quoted.
That is the court which you have approached before.
Yes,
the
under
arbitral
Section
proceedings.
34 I had gone. And this is the court which had appointed the arbitral tribunal.
Yes, we'll hear him.
Yes.
Please, my lord.
No, having said before the court that you have no objections to file and your own for the IAs
I'll answer.
and you only want, want to file for the final disposal. Why did you come here?
My lord, I'll point out. May I be permitted just to place a few facts which my lord will kindly permit me. My lord, straight away from the Section 9 application itself, I have argued even before this court on demurrer. This court has heard me at reasonable length. I have pointed out from the record, from his own application under Section 9, why that order should not have been given. My lord may kindly, if my...
No, all of you are here. I will relegate the trial court to decide that. Why should I?
I'll make a submission, my lord. May kindly... This is not the application shown in the trial court or service application, commercial court. Well, I'm sorry, just show me that. Must be. Where is it? A? I'm asking for the A. I'm sorry, my lord. May I request, my lord, straight from the A itself, because he has said a lot but said nothing. My lord, may kindly turn, my lord, to Annexure B. That is his application before the court under Section 9. My lord, if I can, my submission is this, humble submission. If I can show that from this very application itself, nothing lay, then, my lord, I have nothing further to say. I can go back to the court. My submission is this, my lord. Kindly give me 5 minutes. Please see Annexure B. That was his application under Section 9, under which the order of status quo came to be filed.
Page number.
My lord, page 23 of the writ petition.
Yes.
May I, my lord? My lord, may kindly see the applicants are, as my lord got it, applicants are two parties. My lord, the first party is Rustomji Developments. Has my lord got that?
Yes.
That is a sole proprietorship company. The sole proprietor, my lord, is number 2. Kindly see the age.
Before you proceed on that, when the court has granted an order of status quo,
Yes.
have you raised your objections before the court saying that this application is not maintainable before the court?
Yes, my, that is what I wanted to, and that is
Where are the objections of yours?
my lord, page 36.
Page?
36. And here, my lord, I straight away submit that my learned friend was right. As far as the applicability of Section 42 was not even pressed by me, though I had raised it. And I'm not even going on that Section 42. I concede that the court had jurisdiction under 42. My lord, what I had wanted to request them was only two things. One is take the court through the JDA itself, my lord, because if my lord will see, the entire Section 9 application is premised on one thing. Admittedly, I am the owner of the property. Admittedly, there's a JDA which is almost 32 years old. 32 years old. Admittedly, on my side also, the head of the family is about 82.
Oh, what I'm saying is, why should I consider all this?
That is what I want to get to.
Let the court decide it.
My lord, my lord, I'll tell my lord why. My lord will consider two facts. One, this entire property, my lord.
You have filed an application before the court saying that their application is not maintainable. So let the court
But
decide.
my
Why
lord,
should
my
this
lord,
court decide?
my lord, may I submit one thing, my lord? My lord may kindly see.
Ultimately, whatever
My
you
lord, the-
submit, I will relegate you there. So
My
it
lord,
is
may
just
I-
wasting court's time. that's
No,
all.
my lord, my lord, if it is a waste of time, I'm sorry, but my lord may hear me one moment, my lord. The court has itself, where is that? My lord may kindly see the order. The order that has been passed by this honorable court is after a full hearing.
Where are the reasons? Please
My
read
lord,
the
that
reasons.
is Form 3A. Kindly see. It's the order dated 7th of April.
It just says.
Yes, my
Stay
lord.
of the order.
Yes, my lord. That is what he's seeking to set aside now.
Liberty is reserved to the respondents to file an application seeking modification or vacation.
Of this order. My lord may also see one more note, one more thing, my lord, that it is also said that pending issuance of rule nisi, this honorable court, after going through the facts of the matter, which are very important, and which also consider the age of the property, the fact that there has been a murder in the property, the fact that the owners have been buried inside the property
All
alive.
these things were not at all.
Very well, my
considered
lord.
here.
Very well, my lord. But would my lord consider that this court itself has passed an interim order after hearing parties? Now, my lord, kindly give me some time to show the court why this court passed that order. This court has considered certain matters. Let me kindly place it before my lord. If my lord is of the opinion that this order should not lie.
Whatever are the merits of the matter, I am not inclined to go into the matter because the remedy is before the court. Court will decide. Not that court has no power. It will decide.
No, my lord,
Whatever-
may kindly, my lord.
Or whatever, or you already filed your objection, let the court go ahead with the matter. Why should we, Baba? 226 cannot be used for
My
this
lord,
purpose.
may I cite a judgment of this very court on
Yes,
227?
whatever judgments you cite, I'm going to remand it.
My lord.
Please pass on.
Yeah.
Please pass on.
Just say.
Take that. Yes, paragraph number.
I'll just tell my lord. Para 12.
Okay. No, doesn't matter, share.
Yeah, sure.
Which is the para? At page. Para 12, my lord.
Yes,
40. At page 46, my lord.
yes.
Which is page para 12. Which para? Para 12, my lord. May I?
Yes.
Page 46. May I read, my lord? Answer to point number 3. Whether in view of Section 8 of the Commercial Courts Act 2015, the present writ petition is maintainable. Section 8 of the CCA reads as under. Barred against revision application of petition under an interlocutory order. Notwithstanding anything contained in any other law for the time being, in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction. And any such challenge shall be subject to the provisions of Section 13, shall be raised only in appeal against the decree of the
Not
common.
remanding the matter on this ground.
I'm sorry.
I am not remanding the matter on the ground that it is not maintainable. I am remanding the matter because the court is competent to decide it.
My lord, may I kindly consider one fact, only one fact. I know that I'm sorry, I won't speak a sentence more than that. Kindly see the immense difficulty and hardship. A property is in a JDA for 32 years. Not 1 inch has gone in. The power under the JDA, my lord, does not make a developer the owner of the property or the person in possession. All that has to be considered, my lord. Now,
No, why the trial court cannot consider is my question.
my lord, the point now is this, my lord, that when the applicant now before my lord, kindly appreciate this. He wants specific performance. Specific performance, interim relief has to be in aid of specific performance. My lord, 32 years, nothing has happened. The entire property is wasted. There are aerial photographs that there are jhoparpattis there. Nothing has happened, my lord. Now, what we represented to the honorable court, I'll just say that we had said that, look, admittedly, we are the owners, there's no dispute. Admittedly, there's been a JDA, no dispute. But the JDA is a bilateral document. Nothing has happened for 32 years. Now look at it. Now there's a sole proprietorship.
What is the award?
My lord, the majority award as well as the minority award was in our favor.
It is set aside now.
I agree. That's why I didn't point it. Since my lordship asked, therefore I'm saying. I did not volunteer. But the fact still remains, my lord. It's not even their case that no, the arbitral, that the JD is of yesterday. It is not their case. Their case, my lord, is they're saying that they are in possession under section 53A. If my lord allows me to show that, I will show that how their own pleading.
Let the trial court decide this. I'm not.
Very
going
well,
to-
then it's okay.
Yes.
What can we do?
Can I make one submission?
Yes.
Well, I'm sitting in the fence in the sense, the petitioner before my lord is my sister, and we are co-owners of the property. So I'm supporting the objections to dismiss the section 9 application of the section 9.
Let
I have,
trial court
my
decide.
submission is, my lord, only on legality. Please see the prayer in the writ petition, my lord. It is saying dismiss the proceedings in commercial aid. Now, what learned colleague placed before my lord, the question before the Honorable Supreme Court was, can a writ court in 227 consider an application for dismissal? Because the consequence is, if the Honorable High Court orders Order 7, Rule 11, RFA is gone. So I'm only on the technicality that we should all argue the matter on merits before the trial.
What I'm saying is, he is raising an objection with regard to maintainability. You already raised.
Yes.
If you also want to raise, you raise.
I've
All
raised.
objections will be considered by the trial court. I'll ask the trial court in a fixed time frame to decide all that.
And one more submission. After this Honorable Court of Pleased to grant an order of stay, what has happened is, my lord, because this has complicated the family relationship. My sister and 2 others have executed a sale deed. I have not executed any sale deed. They have misused the order of the court.
Please come. The petitioner is before this court. Question, seeking the following prayer. You are the first respondent.
I'm the respondent number
First
one.
respondent.
1 and 2.
The first respondent has filed an application under section 9 before which is this court,
Commercial court.
commercial court, in arbitration application, by filing arbitration application 110 of 2026. In that, the court has passed an order dated 18/3/2026, wherein the court has observed that on the basis of the JDA dated 1/11/1994, the respondent herein had invoked the arbitration clause, arbitral tribunal came to be constituted. An award was passed on 16/4/2012, thereby allowing the claims of the respondent herein and rejecting the counterclaims of the applicants. The applicants questioned the said award before the commercial court in commercial AS 47 of 2012, and the said court, having heard the matter, allowed the petition and set aside the arbitral award. Being dissatisfied with the said award, the respondent has filed commercial appeal 25 of 2025 and commercial appeal 584 of 2025 before this court. The court observed that since the arbitral award has already been set aside, it is deemed that the JDA dated 1/11/1994 is still subsisting, and the parties to the said agreement should adhere to the clauses. It is a case of the applicant that they are in actual possession for the disputed property. And on the basis of the advertisement given in the newspapers by the prospective purchasers, the applicants apprehend that the respondents may alienate the application scheduled property in order to protect the property in dispute from being wasted or alienated. The court has directed the parties to maintain status quo with respect to nature, possession, title until further orders. In the same order, the court has observed that the respondent number 1 to 3 have voluntarily appeared to their advocate. There is no need to issue notice. Then the court has directed issuance of notice to respondent number 4 and 5 through speed post returnable by 8/4/2026. In the proceedings dated 28/3/2026, the court has observed that the counsel for respondent number 4 and 5 requested the court to grant time to file his objections, but advocate for respondent number 1 to 3 submits that he does not wish to file objections to the main petition or to the pending IAs. He requested the court to take up the matter for final disposal, and he filed a memo citing 3 decisions. For objections to the main petition, the court has posted the matter to 8/4/2026. After the said order is passed, the petitioner has come before the court by filing the instant writ petition. When this matter came up before a coordinate bench of this court, the court has passed an order on 7/4/2026, whereby the court has issued notice to the respondents and granted stay of the order dated 18/3/2026 passed by the court, commercial court, in commercial number 110 of 2026 till the next date of hearing. The respondent
One and two.
one, two,
One and two. One is a
and
proprietary
two,
and
who are the
second is a
applicants
proprietary.
before the trial court, before the commercial court, have filed the vacate petition. Land counsel appearing for the vacate petitioner has submitted that the writ petition, he has drawn the attention of the court to the order wherein the petitioner herein, who is respondent 1 to 3 therein, has refused to file their objections. It is submitted that the relief that is sought before this court is that the commercial AA number 110 of 2026 itself has to be dismissed. Now, dismissed, it is submitted that under Article 227, the petitioner cannot come before this court seeking the said relief. It amounts to the rejecting the application itself. He relied on a order passed by he relied on order of the Honorable Apex Court in case of K. Waller, Matti and others versus Kumarasan, reported in 2025 INSC 606. He has relied on paragraph number 8, 9 and also 10 and 14. In the relying on this, it is submitted that this court cannot entertain this application, and the remedy available to the petitioner is before the very same court. It is submitted that already the petitioner herein has filed his objections, and the court can consider the same, and it is appropriate court to consider all this and pass orders. Next one. Land counsel appearing for respondents 4 and 5 before the trial court, and respondent number
3 and 4 before the court.
3 and 4 before this.
4 and 5.
4 and 5 before the trial court.
Here, my lord, I am 3 and 4.
3 and 4 before this court submits that the writ petition is not maintainable during the petitioner and the respondent number
5 and
3 and you said just now 3 and 4.
No, I am representing 3 and 4.
3 and 4 or brother and sister.
Sister and uncle.
Sister and uncle. It is submitted that I think all other factual aspects are not necessary.
No.
It is submitted that the present petition before this court is not maintainable. Next para. Land counsel for the petitioner submits, yes, he has submitted that this is a case where the court has to consider the litigation between the parties and the nature of the application that is filed before before the commercial court, and this court has to decide about the maintainability of the said application before the commercial court. And it is submitted that while hearing the, while granting interim order, as a coordinate bench of this court has felt that this is a case to be entertained, has passed an interim order. Further, he relies on a order passed by a coordinate bench of this court in WP number 201900 of 2023, arising in case of Krishna Bhagya Jala Nigam Limited and others versus Prabhakar Reddy and others, arising out of WP number 201900 of 2023 dated 11 September 2023. He relied on paragraph number 12.
Take a photo.
Extract that paragraph number. Entire 12 extract. Relying on this paragraph, it is submitted that this court has got ample powers under 227 to decide the application before this court. The learned counsel has made certain submissions on the merits of the matter also. But this court, as this court is not inclined to entertain this petition, this petition, the court is not going into all those aspects. The respondent herein has filed an application before the commercial court. The commercial court has granted an interim order. Petitioner has appeared before the court. According to him, the commercial court has no jurisdiction to decide this matter. He has every right and liberty to file an application. It appears that he has already filed an application.
Memo.
He has filed a memo
Memo.
stating that the court has no jurisdiction to entertain this. The petitioner is at liberty to file an appropriate application before the court with regard to the file an appropriate application seeking the court to decide about the jurisdiction of the for the maintainability of the said application before the court. And on such application, the court can consider the same. So consider the same. This court is not inclined to exercise the jurisdiction under 227 in the light of the fact that already the petitioner before this court, the award which is in favor of the petitioner before this court is already set aside in an appeal, and he is in a further appeal before this court. In these circumstances, the trial court, the commercial court will be able to decide all the disputes that are raised by the between the parties. And in that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to file the appropriate application before the trial court in accordance with law. On such application, the trial court shall consider this after filing that such application, after giving reasonable opportunity to both the to the other side to file their objections. The court shall consider the application as expeditiously as possible.
Bill number 59.
Much obliged.
Let's say interim order, my lords, because they.
Automatically it goes.
Sorry, my lord, one submission. While my lord was pleased to dictate the order, my lord was referring to para 11 of the writ petition, where they have made a pleading. The respondent has made a pleading that as.
12, not 11. Writ petition is relying on.
Well, the writ petition, I'm sorry, section 9 application, where they have made a pleading to say, having been the section 34 arbitration consulate having been set aside, passed by the applicant's rights under the JDA stands protected. That is not written in the order of section 34. It is just their contention.
No. It is not from the order I have read.
No, my lord. What they have written in paragraph.
No, that I have. We are not. Let's not go into all that.
No, I'm saying when my lord is dictating the order, I heard.
No. Give that. What I have dictated is
That we have
that's an
filed an
order.
appeal.
That's an order.
Okay, order.
The order which
Order
they have
does not
impugned
protect the joint development agreement.
states that.
Huh.
The order impugned, page number 22,
Yes.
21, yes.
It says so.
Yes, the order impugned says so.
No, not the order impugned. I'm saying the
No, I'm
section
just,
34 order.
no, the court had only recorded
I have
that
only recorded what is there in the order.
order,
Please.
yes.
I'm sorry.
Much obliged.
Bill number 59.
Now we'll be back and
Raya
forth, back and
for
forth.
petitioner K.M. Prakash.
This is Writ petition, your lordship dismissed with not granted time to vacate the premises, my lord. Now I am intending to move the Supreme Court for grant of time, for 2 years' time before the Supreme Court, my lord, to enable me to approach the Supreme Court, because it is a,
1 year time.
please, my lord.
I should grant 1 year time.
No, my lord, to appeal, to enable me to approach the Supreme Court. That-
Already this order was on 15, when is it? 15?
19th June, my lordship has passed the order. My lord, this is unfortunate. See, he has not
Filed the application.
challenged the order passed by the division bench of this honorable court in commercial appeal, passed in the year 2023. He slept over for 3 years, and now before my lordship has dismissed the writ petition. Now he wants the time to approach without
My lord, I am-
challenging the order passed by this honorable court in commercial appeal. How can he challenge and approach the Supreme Court now?
But I am
Not even a
approaching
single
the
moment
Supreme
is
Court
entitled,
only
my lord.
for the time to vacate the premises, my lord, not for anything, my lord.
Already you had 1 month.
No, my lord, because my lord, it is, my lordship kindly turn to,
Why another set of documents now?
my lord, because to show that the students who are admitted for the academic year 2024-25 and 25-26, my lord, they have to prosecute another one year, my lord. Therefore, my lord, enable the students to complete their course, my lord, to get time to vacate the premises, my lord. They only that, in that view of the matter, my lord, in the interest of students, my lord.
No classes are running, no institution is running. All these things are the earlier photographs and the documents. And when the Amina went near the property, he said it's locked and requested the court to grant the permission to break open the lock. At that juncture, my friend is before my lordships. He can't do such things to drag the matter, my lord.
Shall I call for the Amina's report?
Please, my lord.
Shall I call for the Amina's report? Amin's report.
My lord, yes, my lord, yes, my lord.
Then you will be, if I call the Amin's report and make a finding in this,
My lord,
then you will be at loss.
admittedly, school institution is running, my lord. I'm
By
producing,
locking the
my lord,
institution,
these are
how
the
you are run-
documents, it cannot be created because,
No, how, when if institution is running, how the
my lord,
roads
now
are
the
locked?
institution, my lord, the classes will commence, this nursing course commences from September, my lord. This nursing course commences in the
I've already taken them in the year 7, in the year
no, my lord,
2025.
2024-25, the classes for nursing course commences from September 2026, my lord.
And from which, where is that, the timetable to show
Please.
that the classes commences from September?
It is a government notification, my lord. It is not.
For the government notification.
I will produce it, my lord. If I should kindly have on Monday, my lord, I will produce it.
Kindly dismiss, my lord.
Anyhow, for his satisfaction.
Grateful, my lord.
Monday in the first list. Yes.
Still number 60. SB Matapati for petitioner.
Okay, for petition. My lord,
What is this correction?
It's a year has been changed. It has to be, instead of 2006, my lord, it has come like
Let me look at the order.
this order copies.
It is there, order copy is here.
Suit is in the year 2006, my lord, but in the judgment it came as.
Did you get that?
Lordship, kindly
OS
see the
number?
annexure A, my lord.
OS number 2099 of 2016, correct?
Annexure A, my lord, please kindly, my lord. Order sheet of the trial court, my lord. OS number 2099 of 2006.
2000?
6, my lord.
Oh, instead of 2006, it is mentioned at 2016.
Please, my lord.
In the matter is placed before the court, wherein an IA is filed seeking correction of the order. The number of the suit, instead of mentioning as OS number 2099 of 2006, it is mentioned as 2099 of 2016. I think in the remaining places also you have mentioned it like that.
No, my lord, it's a same.
In the prayer, you look at your
A
prayer.
prayer.
You said so. Anyhow, whatever it.
One
Yes,
humble request.
The updated copy, the corrected copy shall be updated immediately.
One humble request. My lord, suit is in the 2006, my lord. Kindly time frame.
In a correction of order, now I will pass further orders.
100 request.
It is not request. Very unreasonable. Next. Yes.
Still number 61. White Street, Satapati,
Yes.
party in person.
Around 7/6, 8486, I have withdrawn this case, one case, filed in 33724 from this court.
Use the mic.
Yeah.
Mike use Medi, sir.
And 8486 2026, I have withdrawn that one case from this court. The reason is that on 39, there is another case before the GMDRT, that is 39390, in which the counsel of the petitioner, the counsel of the respondent number 1.
Writ petition is still before this court.
Madam?
It is not GMC.
Yeah.
No, what is the order impugned before this court?
I'm asking for this injection on this original order.
Injunction on the
I
original
will go to the case directly.
No, come to the prayer first.
Prayer,
What is the
prayer
prayer you are seeking?
Injection.
Issue a
Prayer
writ
is
of
injection.
mandamus, grant an order of injunction in OS number 2413 of 2025, which was granted earlier dated in OS number.
2134. The matter.
Why these people are numbering these writ petitions like this?
No, sir. This is correct, madam. Actually, on 1511, they filed the position notice. So at that time, I have filed a case in 2134 before the principal court, Bangalore Rural. At that time, this number was 2134/2024. And on that case, I got the injection on 9/12/2024. Subsequently, the case was transferred to Civil Court in JMFC KR-Puram. Then the number was transferred. This number was changed to new number 2413/2025. And in 2000, this order was dismissed on ground of non-maintainability ground. Whereas in 2134, I was ordered to pay the evidence. This is the only difference over 2413 and 2134. 2134 is before Principal Judge, Bangalore Rural, and 2413 is the court is the.
You can't file a writ petition like this. Court will not grant an injunction here. There should be an order of the court.
Yes, madam, a court order is there.
You are not questioning that order. You are independently seeking injunction.
No, I'm putting all the orders, madam.
When did you appear before this party in person committee?
I have not appeared party in person. You are my, sir,
He has not appeared.
Yeah, you have allowed.
He has appeared.
No, I have filed 2 cases, madam. 12 I have.
The petitioner shall appear before the party in person committee. Yes. Next.
Serial number 62, preliminary hearing B group. Sridhar Prabhu, for
Lord,
petitioner.
Before I commence
For the
arguments, my lord.
respondent, my lords. Some inconvenience today, my lords.
No,
Kindly
I have
it.
one proposal, my lord. I have factored this. In fact, my lord, this matter may be relegated to the KERC without your lordships going into the merits for this
My lords,
reason.
we have opposition on that, my lords. It has
And
to be
I have
heard, my
not
lords.
opened my.
What is that you saying? That
What
here
to watch?
I'm not going to pass any order.
Yes.
Yes.
No, in fact, my lord, one of the contentions that I have taken is that, my lord,
So what is the prayer that
yes,
is sought
prayer is,
before
my lord,
this
to set aside the KERC's order at Annexure A, page 53. The lead matter is, my lord, 8775. And the order of KERC, Karnataka Electricity.
KRC has passed an order that is questioned before this
Yes,
court.
before this.
So why you want to go back?
Yes, I'll submit, my lord.
That
This-
means we have to set aside this order.
Yes, I'm submitting for this reason, my lord. The first contention I have taken is, and that, my lord, may merit consideration, that there is a case decided by the Honorable Supreme Court in Utility Users Association, which says if there is no judicial member in the regulatory commissions, then, my lord, the orders may be vulnerable to challenge. Now, the subsequently, my lord, the learned single judge of this Honorable Court considered this aspect and said it has prospective effect. It has no retrospective effect. But having said that, this matter, my lord, it's barred by res judicata and many other issues, my lord, are legal in this matter. If there is already a judicial member appointed now.
We'll hear him. We'll hear the other side. What is their
Yes.
objection? Yes, let's this matter on Thursday. Interim order earlier
Interim
granted
orders
is
may be
extended.
involved.
Yes, next.
Interim orders may kind.
Extended.
Serial number 63. Uma Shankar, MN for petitioner.
Okay, for the respondent, please.
Anjana.
There's an interim order.
Yes, ma'am.
No representation for the petitioner. Counsel for the respondent is present. Let's this matter in the month of September. Don't extend the
Milord,
interim
Milord,
order.
I have moved the memo before the trial court matters.
I'm not extending the interim order.
Please, no, because they
It
will
is
not.
made clear that the trial court can go ahead with the matter. Yes, next.
Serial number 64.
I'm for the petition, my lord. Kindly have it on Monday, my lord. There is no interim order in that matter.
I appear.
If there is no interim order, no Monday. Will.
64, yeah.
There is an interim order
there,
is
man.
there.
Huh?
Interim
64
order
is the interim order is there.
64, I am the petitioner, my lordship.
Then who is saying that interim order is not there?
No, I am the Vasant Raj.
Yes.
Kindly have it Monday, my lordship. Arguing council.
It is a simple
21 held
matter,
up in
please, lordship.
2024, you enjoy an interim order and now you say that again it has to come up.
Arguing
on
council
some-
held up in 21 Kotal and 21, my lordship.
Let's just matter on 27th in the first list.
Interim order, extend.
Order earlier granted is extended. Yes, 65.
Serial number 65. Serial number 65.
For the respondent.
Chirag.
65, I'm appearing for the petition, my lord.
In this, no interim
My
order.
lord,
This matter
no
in the
interim
month of
order, my lord.
September. Yes, next.
Serial number 66. Serial number 66.
For the
Vasant
petitioner.
Vincent Fernandez.
My lord, this was a suit filed by the mother against the son. We sought for rejection of the plaint.
There is a respondent. You have an
My
interim
lord,
order.
she passed away.
You have an interim order.
I have an interim.
Yes, this is matters in the month of September. Yes,
Madam.
interim order, look at it wherever interim order is there, extend.
Serial number 67.
Yes.
Lord, I appeal for the respondent.
Aditya Narayan.
I appear for the petitioners, my lord, seeking for a short accommodation.
Lord, similar matter is on 27.
20?
27.
Give the number, list.
17216.
List.
I'll.
Write on a
Mazur.
paper. This is
Interim
matter
order may
along
be
with that.
extended, my
Huh?
lord. Interim order may be extended, my lord.
Interim order earlier granted is extended if, on the next occasion, if extension is sought, on that ground, the petition will be dismissed.
Serial number
Yes.
68. You are connected number
Extension is sought without arguing the matter. Yes, 68.
68. Varun S.
My lords, I beg to appear on behalf of the petitioner, my lords. In 2020, we have filed a recovery suit before the Learned City Civil Court. And in 2023, we have amalgamated into a bank. So now we are HDFC Bank Limited. Pursuant to this, we have filed withdrawal IA since the Learned City Civil Court doesn't have jurisdiction, pecuniary jurisdiction to proceed with the matter. The same was rejected on 24th September 2024. We are before this honorable court to seek direction to permit us to file fresh affidavit along with the withdrawal IA.
Why you should come before this court to file a fresh petition?
My lords, by the order dated 24th September 2024, our IA was rejected. We want to withdraw the suit since the Learned City Civil Court doesn't have pecuniary jurisdiction. The suit amount is above 20 lakh. So we want to approach Learned DRT.
Discussing your application.
My lords, in our application, the government was disclosed in very brief, so we are seeking direction of this honorable
No,
court.
set aside this order and again, I mean, permit them to come up with an appropriate application at the court consider and pass.
That was even the order passed by the trial court, my lords, directing them to file a better affidavit. They do not file a better affidavit, instead they file this WP. And then they stay their
Then you
own
will
suit.
send it.
Please.
My lords, kindly permit us to file fresh affidavit.
The
Previously,
writ
engaged
petition is passing the following prayer. The trial court, by order, when the petitioner wants to withdraw the withdraw the suit and file an application under 23 rule 3, the court has dismissed the same by order impugned. Where is that? Page number?
My lords, annexure E, page number 86, my lords.
The court has dismissed the application, observing that in absence not satisfying the order 23 rule 1 CPC, the question of plaintiff's permission to withdraw the suit with liberty to file fresh case does not arise. As per the order dated 27/6/2024, the plaintiff has sought time to file better affidavit in support of the application. Even thereafter, no such better affidavit is filed so as to comply the provisions under Order 23 Rule 13 CPC. Therefore, as per application, there is no formal defect or sufficient ground for the plaintiff to withdraw the suit and accordingly reject it. And counsel for the petitioner submits that there is some communication gap. As such, they could not file the better affidavit. Hence, this order may be set aside and the petitioner may be permitted to file a better affidavit and a fresh application under Order 23 Rule 3. And counsel appearing for the respondent submits that the court has already granted them time. In spite of that, when they failed to do so, the court has rejected the application and there are no grounds to interfere. Next paragraph. Having heard the counsel on either side, there is the material on record. The petitioner has filed an application under Order 23 Rule 3 seeking to withdraw the petition. However, the application that is filed is insufficient. Court has given them the reasonable time, but in spite of that, when the petition has failed to file, the court has rejected the IA. Considering the facts and circumstances of the case and balancing the interests of the parties, this court is passing the following order. The order impugned dated so and so is set aside. The matter is remanded back to the trial court. Number 2, the petitioner is permitted to file an application afresh under Order 23 Rule 3 along with the budget affidavit, and the court shall consider the same in accordance with law. Yes.
Number 69, Article 70. Till number 70, S.V. Prakash.
70.1 and 70.2.
Yesterday's matter.
Yes, can this be taken on Monday, my lord?
Monday, 2:30 matter, sir. Look at it. She will give it on Monday or Tuesday at 2:30.
This I will understand.
Monday already 2:30 matter is there. So Tuesday, Wednesday, any of the 2 days, give that matter.
Firstly,
Another matter is there. Only give one 2:30 matter one day. Wednesday.
please, and the top up is because it has substantially.
No, I'm not taking up top. The other day I've taken 2 matters.
Please.
The entire day I couldn't complete the list. That's why I'll take it up at 2:30. I'll sharp take it up at 2:30.
Please.
Yes.
Interim order.
Interim order, look at it in which matter interim order is there extent. Yes, 71.
71, Balraj VR. Balraj VR.
I'm serving the copy to the.
Kamini Ganesh.
Copy is served now.
Yes, my lord. The matter was listed yesterday. And it was urgent for today to serving a copy. I served the copy, my lords.
Monday?
It can be disposed of.
But so far as
It
the
was
instructions-
similar 3 matters. The lordship has disposed the matters, my lords.
What is this? KEB matters. I'll take it up Monday. It's already 4:40. Yes, Monday in the first list.
Great.
Yes, 72.
Till number 72, Ajit PB.
Nothing for the petitioner, Your Lordship.
P.S. Karthikeyan.
Your Lordship, you're challenging the order passed by the.
Already 4:48. That's why the counsel for the respondent is not here. This is matter in the first list on Monday. That's 73.
Till number 73,
Monday.
Same. 73 also same, Your Lordship. Much.
till number 74.
74 listed in the month of September. You are there? Or you are the one saying urgent? This matter also.
Petition, 2:30 maybe, my lords. Any day,
2:30
2:30, my lords. 2017 petition, my
I
lords.
remember, she'll give you the date in the coming week. Yes.
List to serial number 8.
All interim order will be extended.
Please.
Please wait. The court officer, I have already instructed her.
My lord, in serial number 8, my lord, there is no interim order in this case, my lord.
Serial number 3 in the second list, I'm sorry, madam. No interim order was being made either. Last time it was refused. The parties.
Number 50, madam.
That's why I have told her. So if she will be giving the dates whenever you want.
Last time it is not.
May I
extended,
request,
but I
my
am the
lord,
respondent.
matter to be
That's why
posted in the
it is not
first list,
extended.
my lord. 4 cases come up in second list, my lord. Request for the first list, my lord.
No, urgency. What is urgency to take it up in the first list?
The matter is there, posted for final hearing, my lord. My application was rejected by my application, production of documents.
So what you ask your colleague to give a memo on Monday.
Today's list, your lordship may post it on Monday. I'm requesting for Monday, my lord. I mean, sorry,
What
on the
happens
first list,
is-
my lord, any day of first list.
What
my lord.
happens is like to accommodate everyone and to, for a smooth functioning, I have evolved a mechanism. In that, this won't fit.
Sorry, madam. Last time refused, court has refused to extend the
Four
order.
days,
Serial number
my
8, my lord.
Cannot be extended.
Madam,
ಮೇಡಮ್ ಇದು ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀರಾ ಮೇಡಮ್?
ಸರ್ ಡೇಟ್ ಅಸೈನ್ ಮಾಡ್ತೀವಿ, ಇಂಟ್ರಿ ಮಾಡ್ರು ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಪಾಸ್ ಅವರ್ ಎಲ್ಲ ಮಂಡೆ ಪಾಸ್ ಅವರ್ಸ್ ಇದೆ ಅದೊಂದು
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇಲ್ಲ, ರಾಂಗ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ತಾ ಇದೆ.
ನೋಡ್ತೀನಿ ಸರ್.
ನೋಡಿ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಗೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ ಲಿಸ್ಟ್.
ಪಾಸ್ ಅವರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 38 38 ಸೀರಿಯಲ್ ನಂಬರ್ 38 ಫಸ್ಟ್ ಲಿಸ್ಟ್ 43, ಆಮೇಲೆ 44, ಆಮೇಲೆ
ಥರ್ಡ್ ಮ್ಯಾಟರ್. ಹೋಗ್ತಾ ಇದ್ದಪ್ಪ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಆಯ್ತಲ್ಲ 50 ಆಯ್ತಾಯ್ತು. 3 ಮೀಟರ್ ಮಾತ್ರ ಅಲ್ವಾ?
43 ಪಾಸ್ ಆಗಿದೆ.
Serial number 3 in the second list.
ಅದು ಎಂಟ್ರಿ ಮಾಡಿದ್ರು ನೋಡಿ ಲಿಸ್ಟ್ ನಂಬರ್.
Madam, serial number 3 in the second list.
ಸರ್ ಒಂದು ನಿಮಿಷ ಸರ್, ಇಲ್ಲಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು ಇದುವರೆಗೂ ಇದೆ, ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Serial number 8 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 8 ಅಲ್ಲಿ
ಆ ಡೇಟ್ ಎಲ್ಲ ಆಗಸ್ಟ್ ಎಲ್ಲ ಫುಲ್ ಫಿಲ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ
ಮೇಡಮ್.
ಅಕಾರ್ಡಿಂಗ್ ಟು ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
ಮೇಡಮ್
ಮೇಡಮ್ ಮೇಡಮ್